CR1 is now in session.
Good afternoon. Please be seated. This is the time set for oral argument in Markham Contracting against FDIC. Our cause number 1CA CV14-0752. Counsel, I know you're all familiar with the workings of the court. We have conferenced this case, read the briefs carefully. We're ready to go, and you can bear that in mind as you begin your presentations. We are being audio and video recorded today for preservation on YouTube, so if you'd be good enough to announce the party you represent and your name when you approach the podium, we'd appreciate it. Each side has 20 minutes for oral argument, and of course the appellant may reserve as much time as you're able for rebuttal, subject to watching your own clock. And with that, we can begin.
Good afternoon, Your Honors. Thomas Hudson on behalf of the appellant Markham Contracting, and with me at counsel table today is Karen Palasek and Eric Frazier, and I hope to save 5 minutes for rebuttal. Your Honors, at bottom, this case is about whether a lender may acquire property at a trustee's sale by making a credit bid available to it only by virtue of a junior deed of trust, and then later claim rights under a senior deed of trust. We submit that it may not for at least two reasons. First, under basic subrogation principles, a party claiming subrogation is limited to the rights and limitations of the person paid. In other words, whether it's equitable subrogation or replacement, a lender claiming those rights can never have more rights than the original lender. Second, if the court were to construe the law to be otherwise, it would wreak havoc with trustee sales and the lien priority dictated by statutes.
So on your first point, are you really driving then at the fact that the credit bid here exceeded the priority amount?
I am, Your Honor.
Okay.
And going to that second point, why we think that's so important, Judge Swan, is that, again, if the rule were otherwise, it would mean that lenders could, pursuant to a junior interest, later claim a senior interest, wipe out intervening lien holders in a manner clearly inconsistent with what the legislature intended.
Well, I don't think there's much doubt that the statutory definition of credit bid wouldn't permit an excess bid. But the appellees make the point that it doesn't really matter in this case, because if they had bid less, they would have extinguished your client's lien.
But they didn't, Judge Swan. And our point is that two things. What's the rule going to be? First, if they're going to be claiming rights that they have by way of subrogation or replacement, they have to be limited to the rights of the senior lender. They don't get extra rights. And again, if the rule were to permit that, as we explain in our brief on page 50, it would allow lenders to come in and essentially wipe out intervening lien holders in a manner that the original lender could not have done. So that runs squarely into the limitation in the restatement under both replacement and subrogation.
I don't know that that proposition is terribly controversial. The question is whether it applies here. So let me ask see if we're on the same page on a couple of basic ideas. With regard to the amount outstanding on the original senior loan, you would agree that through whichever doctrine, equitable subrogation or replacement, the lender acquired priority on the 2008 loan, right?
Correct. Up to 2.9.
Up to 2.9, sure. And if the bid at the trustee's sale had been exactly that amount, or exactly the amount then outstanding plus costs, that Markham's lien would have been extinguished.
We do not agree with that, Judge Swan.
Okay, and why is that?
Okay, so, and let me make 2 points on that. We think this is an easy case because they made a credit bid in excess of that. But let's be clear what happened in this case. The lenders notice a trustee sale. Markham sends a letter saying, we have priority. A week later files a lawsuit. It's not served. The lenders on January 12th send a letter saying, we didn't know you were going to claim priority, and we never got notice, saying the lien's not valid. After that letter's sent, Markham serves them with the lawsuit, lien judicial foreclosure. So clearly they are on notice that there's a dispute about priority. And one thing and then what happens is they hold the trustee sale, acquire the property pursuant to this credit bid in excess of what they're allowed to do, answer, again, don't say anything about equitable subrogation, instead say that the lien is invalid. and the prejudice to Markham, and really what you don't want to have, the way that you don't want the law to work is, had Markham been on notice that they were going to be claiming that Markham's lien would have been extinguished, Markham could have done something at that point to protect its rights. Markham could have either filed a lawsuit to enjoin the trustee sale, or Markham could have shown up and bid.
So let's say there had been adequate notice, right? Undisputedly adequate notice that the lender was going to claim that priority with respect to the 2.9. They came in with a credit bid of exactly that amount. Would Markham's lien have been extinguished then?
Well, if Markham had noticed, Markham then could have been 2.9 plus $1 and acquired the property.
Sure. But if it had not, let's say it couldn't come up with 2.9, would it have lost its lien?
Yes.
To the credit bid
If there had been notice, I agree with that, Justin. If there had been notice and assuming under the facts of this case, had they had notice, they wouldn't have waived the right. And let's be clear, subrogation is not automatic. Subrogation is a right that has to be exercised.
Okay, thank you.
Okay. So again, and just to make our position clear, this is the easy. We think there's prejudice in this case because of what happened. Because there's clearly a dispute about priority. Markham is asserting its rights. They go and hold the sale and don't notify anybody what they're actually intending to do. But it's worse than that. They then make a credit bid, which they were absolutely free to do. And let's be clear. Unquestionably, in this case, they made a credit bid that they only had by way of rights under the 2008 deed of trust. And they were absolutely free to do that. But once they elected to do that, whatever rights they had under the 2006 deed of trust are gone, and Markham's lien remained on the property. And again, conceptually, we submit that the law really cannot be otherwise, or you're going to just create all kinds of problems for trustee sales. And you're going to undermine the market incentives that are supposed to occur when a trustee sale happens. People have to know what rights are being claimed and how the bids might unfold. And look at the math here. The 2.8. So you have the 2006 deed of trust is 2.8 or 2.9, depending on whether you count interest. You add in Markham's lien of $341,000. That's 3.17. They come in at 3.175, which is, which is of course the amount of the highest appraisal as well.
And if it had been a cash bid, Markham's lien simply would have been paid and then extinguished.
Absolutely.
Okay.
Absolutely. Okay.
So when you say the law cannot be otherwise, I want to make sure we're very clear on what that is. If the law is that they're subrogated or replaced, but only to the extent of the original obligation, leaving everything else sort of subject to later decision, do you have a problem with that legal proposition?
I do, Your Honor, but again, that's not this case because of the credit bid they made. If they had, as we just discussed earlier, if they had simply made a credit bid of 2.9, this would be a much harder case. Our position, as I just outlined, is there is prejudice in this case, and the restatement makes clear that a party, if there is prejudice to intervening lien holders, a party doesn't get subrogation, and there was here on the facts of this case. But I don't think the court needs to reach that issue. I think that is the law and the better rule. But this is a simpler case simply because they exercised rights they only had by way of the 2008 deed of trust, and they were free to do so, and having elected to do so, whatever rights they had under the 2.6 were gone.
What if the bid had been 2.9 plus $100,000 cash? And the $100,000 went to Markham,
Yeah.
but the remainder of the lien was then extinguished.
Yeah.
Would that offend your sense of how the law should work?
No, as long as there was notice.
Okay.
Yeah. Okay. So I really don't have a lot more to add on that. I'm happy to discuss why it's important for people at trustee sales to understand what's going on, why that's important to protect, why the statutory scheme is set up that way. So unless the court has more questions on that, I just think the final point I want to make, and I'll reserve the balance of my time for rebuttal, is that we submit that nothing in this case turns on the distinction between replacement and subrogation. But this was not a replacement loan. It was a new financing, multi-party financing. So to the extent there are any differences, and we don't think there are, subrogation is the doctrine that applies. Thank you.
May it please the Court. Scott Malm of the law firm Gust Rosenfeld, representing the FDIC. With me at council table is Richard Nye, who represents Prime AZ Libra. Markham started work knowing that it was behind a recorded $4.1 million deed of trust, and now is complaining because it was foreclosed by a trustee sale with a bid of $3.1, much less than the $4.1 deed of trust, $4.1 million deed of trust they were willing to be behind. When the new loan came along and replaced the old loan, it did not substantially change terms. You've not heard any allegation of that. And according to the restatement 7.
The old loan wasn't worth 4.1 at that time. It was worth 2.9.
If you're talking about how much was owed versus the amount of security that existed, that's the distinction I'm drawing. You're right that only at that time 2.9 million was owed, but 4.1 million is the cap. This was a construction loan, like a home equity loan. So they could have gone up to 4.1, and they were fine being behind $4.1 million deed of trust.
Well, let's talk about that sequence just to make sure we understand it. The original loan was for 4.1.
The original deed of trust secured a construction loan with a maximum balance of 4.1 million.
But that was not advanced.
The total was not advanced, correct.
Okay. So when Markham took its second position, how much had been advanced?
I don't believe it's in the record how much on the very date that Markham started work, how much of the construction loan had advanced. But the point is that the deed of trust giving them notice that they would be behind up to $4.1 million was of record. It may have been $100, it may have been $4 million, and then had been paid down to $2. That wasn't developed in the factual record.
But I guess the question then is, the parade of horribles in the appellant's brief then suddenly leaps to mind. Are you suggesting that 4.1 million is the cap for all time, and then if the actual senior loan is $10,000, that a subsequent lender can come in and acquire a $4.1 million priority?
If they paid off, no, I'm not saying that.
They pay off the $10,000 and also lend an additional $4 million or so. You're not saying that they can take priority up to whatever the max was in the original deed of trust?
No.
Okay. So
Replacement would only go to the amount that was due at that time. Yes, the amount that was due at that time is what replacement doctrine applies to.
Okay, so why is the 4.1 relevant? I'm sorry if I'm not following.
Simply because what I heard from them was, hey, you wiped us out with a $3.175 million bid. We had no idea that could happen. You only were owed 2.9. And my point is, because notice was one of the issues that was raised on the opening, at the time they started work, they knew that they could have been foreclosed based on an amount up to 4.1. So this shouldn't have come as a real shock. And to continue on that notice issue, we can break this argument into lien priority, which is whether replacement and equitable subrogation. We didn't hear a lot of argument there on opening. I'll come back to that in a moment. But to focus then on lien termination, the issue I heard there was if they had notice before that trustee sale, I heard a concession that everything would have been fine with this trustee sale. Go back and look at the January 2010 letter from Snell and Wilmer that was sent on behalf of the lender. It is in the record it's in the appendix. It's January 2012. It is January 2012, January 12, and it gives notice to them. It's at the volume 108, volume 2, page 108. The specific language is Markham is told that that the bank's loan was insured, showing its deed of trust as a first lien. So Markham may say, well, we didn't know specifically equitable subrogation, but they cannot claim that there was no claim to a first position lien as of January 2010, which was before the February 2010 trustee sale. They're on at least inquiry notice to say, well, why would a title insurance policy insure them in first position? And the answer is replacement subrogation.
Okay, and let's assume that that's true for a moment. You place a lot of weight on the distinction between replacement and subrogation. Would you like to go?
Yes, we'll talk about the lien priority part first. The distinction is to understand that equitable subrogation has been around since the 1930s in Arizona, since the Mosher decision. But as that doctrine has evolved, when the restatement came out, it pulled out of the larger subrogation concept a specific situation, which is this situation. And that's the replacement doctrine of 7.3 in the restatement, which says we're not going to allow junior lien holders, intervening lien holders, the right to veto new financing that needs to happen, to stop the situation where a owner needs more money to keep the project going because it's for the benefit of the owner, it's for the benefit of the intervening lien holder, and it's better because then the project can continue to go on. And so out of the larger equitable subrogation is this specific situation, not only single lender financing. That's a misnomer. The language of the restatement 7.3 specifically says in the same transaction. So as long as
we don't have the transactional documents in the record here.
No, we don't, because it was conceded in the Statement of Fact, Statement of Fact 8 with the Statement of Fact 9 in Index of Record 285. It's on page 129. The allegation from Markham was, as part of the same closing, the new deed of trust was recorded and the deed of release, the release of deed of trust was recorded as part of the same closing. So you didn't need all of the underlying transaction documents to look at because they alleged it was all part of the same closing. And we said, you're right, that's undisputed. So that would apply replacement 7.3 as a doctrine because the language isn't single lender. The language in the restatement itself says in the same transaction. And that's this case. The reason that's important is because then the restatement explains that it would be in the rare situation where you would not allow the new replacing deed of trust to have the priority of the prior deed of trust.
And then you contend that if this is replacement, that concepts of unjust enrichment are essentially irrelevant.
Well, remember, unjust enrichment was a specific claim brought in the lower court by Markham. The lower court ruled against them, and they have not appealed that. So
well, that's an affirmative claim, but if one reads the restatement, equitable subrogation clearly You almost can't have the word equitable in there without having some concept of unjust enrichment, and yet you contend that replacement doesn't contain that concept, right?
It does not contain the same level of analysis as you might get in equitable subrogation, correct? Because the restatement itself says that there's only the two exceptions, a material change in terms or the intervener takes title when nothing of record, and that's not this case.
Well, your brief, actually, at page 19, says that the replacement doctrine is not limited by the caveat that it will only apply to the extent necessary to avoid unjust enrichment. Do you stand by that? Because, I mean, I just read directly from the brief.
You're right. Unjust enrichment is not part of the analysis. It shouldn't be.
And you cite for that the White's case, which doesn't even talk about replacement. Is there another source of authority?
The restatement itself. The restatement itself only identifies two elements, which is the material change in terms and the intervener takes title when nothing of record. Those are the only two exceptions. So when
But
we
White's
cite,
didn't hold that.
well, no, because you're right. White's was equitable subrogation. So I believe in the brief where you're citing from is at the point where we were talking about, okay, if you want to talk about equitable subrogation, we'll talk about equitable subrogation and what the analysis is there. If you're going to impose an equitable subrogation analysis on it, then we'll go down that road. We would never suggest that White's was dealing with the replacement doctrine.
Okay.
Let me go back then. Besides the lien priority issue, replacement versus equitable subrogation, the lien termination, the parade of horribles that we heard, and how terrible this would be of a system, well, it's worked pretty well in Texas. We cited the Chicago title case, the Texas appellate case from 1989, that is on point with us, that you don't need a declaration of equitable subrogation before the trustee sale. For whatever thing you may think of Texas, I haven't heard a real big problem over the last 26 years of their foreclosure situations. GE Capital, the Maryland highest court of last resort, 1995. Same holding as what I'm advancing here. District Court of, highest court from the D.C., from the District of Columbia, 2006. Same holding. You do not need to claim or have a court declare equitable subrogation or replacement before you hold your foreclosure sale. There are 3 jurisdictions that have held what we are suggesting. We haven't seen one case cited from them, and I haven't heard of any of the horrible things going on that what you were told happened here.
Let me just then switch gears. Why the excess credit bid?
It's statutory.
Well, it is, but I don't see a statute that allows you to make a credit bid for more than the lien amount, and your priority lien here was 2.9.
There's a misunderstanding of what the definition of credit bid is. The credit bid is not relating to priority. Credit bid relates to amount due. Means a bid made by the beneficiary in full or partial satisfaction of the contract which are secured.
Well,
that's the distinction. There's a contract
true.
that's secured. What contract was secured by our priority position? That was our note. How much was owed on the note? 3.175. So we followed that statute in making a credit bid pursuant to what we were entitled to do. Now, priority.
To the extent part of your contract is junior, I mean, you can make all the credit bids you want on a junior contract, but you're not going to extinguish the lien.
With all due respect, you're confusing contract versus encumbrance or lien position, the security.
Well,
the
no,
contract,
I'm going to the purpose of the bid, which was, at least in part, to extinguish Markham's lien.
that is the effect of getting a trustee's deed, correct. But how much is to be bid? The statute says we are allowed to bid up to the amount of the contract that is secured by the deed of trust. We were foreclosing our 2008 deed of trust with the priority of the 2006 deed of trust. So what amount would you credit bid? 3.175. That was how much was owed. Now, if that created a problem where we credit bid something that wasn't in first priority, the trustee should have done something about it. They brought a claim against us for unjust enrichment. The court rejected it and said, you should have gone after the trustee. They didn't.
But if the trustee should have done something about it and the trustee didn't, wouldn't the equitable remedy be to leave the lien in place?
No, because under BT Capital, which says when a trustee's deed is issued, we need finality. The same with the Pappas case from the District of Columbia, 2006. The purpose of our foreclosure statutes is to get property moving so it can get on and to get the money taken care of. So no, I would disagree that that would be the equitable thing. That's not following the statute. Now, if what you're arguing is basically unjust enrichment, they should have pursued their unjust enrichment here, and they didn't. They abandoned
need the
it.
equitable thing here, because if you just followed the statute and BT Capital as written, you'd lose because you're junior. You need equitable subrogation or replacement, which is not in the statute, but a judicially created doctrine to get you your senior priority, which I think everybody agrees you have, at least to some extent.
We would disagree because
maybe not.
it's
Maybe there's not such universal agreement, but
the doctrine applies as a matter of law. As soon as that payment is made, that 2008 deed of trust has priority. Maybe it doesn't have the court's declaration yet, but as the courts have talked about the operation of law, that the doctrine applies as a matter of law. It's at that time. It's like an assignment is the recognition. The illustration I would give you is if I have a prescriptive easement, after my 10 years, the prescriptive easement exists, but I don't have it finalized before the court. That doesn't mean I don't have it. Same thing here. We had priority as soon as the money was used to replace the 2006 by operation of law. So that's why I say I don't concede your premise, which is that we were junior. We were never junior in the 2008. We were senior to the amount of 2.9 plus accruing interest, and we were only junior to a small amount of money. Now, when that credit bid was made and it was too much of over our priority, they should have done something about it. They knew.
Could they have done something about it? Would you concede that had they done something about it, they would have won? In other words, that there was some money out there that should have gone to Markham but didn't for whatever reason?
Statutory priority would have been if we bid too much, then there would have been a reason for the trustee to have said, please put more money on there. We would have to concede that we were only in first position to a certain amount.
But
yes.
Then the problem becomes, and I don't think there's any case on this. This is, as far as I know, a case of first impression. The problem becomes when the extra money that should have been distributed otherwise is in the form of a credit bid as opposed to cash on the trustee's desk. What is the trustee supposed to do? Issue a credit note? I don't know what the trustee could do when the excess funds are in the form of a credit bid.
The trustee should not have accepted those funds then. The trustee should have said you are only in priority to a certain dollar amount. The trustee should have ensured that it didn't, it could have demanded the payment. Had Markham, once it had notice in January of 2010 that the title insurance company had insured the lender in a first position, it could have gone into court and we would have had these priorities declared. By the way, in January, the 2010, the complaint that they were talking about was filed. It also includes a request to talk about priorities, to declare the priorities. They knew priorities were at issue. So if they sat back and let the sale happen, then let the chips fall where they may. We bid at that sale, and I think it would be a violation of BT Capital to upset the trustee sale. That would be a classic example where something went wrong in the sale process, and the court basically said, you should have stopped it. You need to get involved and you need to stop that sale, because once that sale happens, regardless of whatever bad things may have happened in that sale, the statute says that trustee's deed is controlling. Could they have made an unjust enrichment claim for that excess proceeds? That was probably their best case. That was probably their best claim. The lower court rejected it, and they didn't appeal it. So I would request that you not try to give them the relief that maybe they would have been entitled to had they kept their unjust enrichment claim alive by upsetting lien priorities arising from the deed, the trustee's deed being issued and recorded pursuant to statute. And that would be consistent with the 3 other jurisdictions that I talked about and their philosophy of wanting properties to keep moving.
It sounds, I mean, you raise an interesting point with BT Capital, but it sounds as though you're conceding that something went wrong here and there was some extra money that should have been paid to Markham. It just wasn't. Is that a fair interpretation?
If the case was that my client had 2.9 in first position and was behind Markham, the process would have been that any excess money would have gone to them. Yes, I have to concede that because that's the statutory process.
Sure,
the question is, whose fault is that? And what I'm telling you is the fault is 2 parts. 1, the trustee, and they should have sued the trustee, but they didn't in a timely manner. Or 2, it would be a claim for unjust enrichment, which they did assert in the lower court, but now haven't presented to you. So, yes, I concede what your point is in terms of what the statute would require, but don't upset the lien priorities. Don't upset the effect of a recorded trustee's deed, because that would violate the statute 33808, and it would upset or not be consistent with BT Capital. So we ask that you affirm the lower court on all grounds and declare that we do have a first lien position under either replacement or equitable subrogation, and that their mechanics lien was terminated. Thank you, Judge.
Thank you.
Judges.
Let me just start by noting that it is a case of first impression, Judge Swan. There's no case ever that they've cited or that we've been able to find that has said that a party can come in and make a credit bid in excess of what the first priority position would have been and extinguish the lien. And in fact, the GE case that they cite, if you look at it carefully, the court was careful to frame the issue in terms of whether the intervening judgment liens are extinguished when the amount of bid at the foreclosure sale does not exceed the portion of the debt entitled to be equitably subrogated to the first priority position of the refinanced deed of trust. And that's on pages 1174 and 1175. Second, they had every right to bid a credit bid up to the full value of the amount secured, the amount lent on the 2008 deed of trust, which was roughly $4.4 million. So there was nothing for the trustee to do at the trustee sale because they didn't do anything. They acted within their rights. And then let's talk about this January 12th, 2010 letter. There's nothing in there saying we believe we have priority and we're going to foreclose on our priority interest. They say they bought insurance. And of course, when you go look at the title policy, it says work shall not commence on the property, and if it does, we may have to delay funding the loan. And what realistically is a contractor in Markham's shoes supposed to do? Go sue to enjoin it, and the court's going to say, well, they haven't done anything yet.
Why doesn't BT Capital require you to sue to enjoin the trustee's sale when you know it's going to happen?
Because in this case, let's think about this, Judge Swan. So there's this letter. Markham has filed its lawsuit. Gets notice of the trustee sale, asserts its first priority position, gets a letter saying we have insurance, which doesn't really raise the issue. So Markham sues, and there's really not even a dispute yet because they haven't made their position known. And so what you're going to do is put contractors, here's the choice. Either have people when there's conflicting positions over priority, have the lender make clear its position if it's going to claim equitable subrogation or replacement, so that everybody at the trustee sales knows what's going on, or have contractors guess when in this case they had every right to bid 3.125. Markham couldn't have enjoined that. They were acting well within their rights to do that.
But you're not claiming that Markham seriously thought that it occupied a first position with respect to the entire 2008 deed of trust?
Well, in fact, Judge Swan, that is what happened. But we are recognizing these doctrines. And truthfully, in 2000, when this was going on, no one was thinking about these doctrines. I think you can see that by their conduct. You can see it by Markham's conduct. We didn't have the White's case that foreclosed or that said the doctrine can't apply in the context of mechanics liens. But I don't think that matters. What matters is that they made a credit bid beyond what they had the right to do under the senior interest. And that, in our view, ends it. Now, let me note, too, we've talked about replacement and equitable subrogation. Replacement has the same limitation. It's in 7.31a, which talks about material prejudice when the terms change. And implicit in that is the idea that you are limited, anybody claiming replacement is limited to the rights of the original lender. You don't get any more rights under replacement. And there's no case that says that. And did that answer your question sufficiently, Judge Swan, in terms of?
Well, I don't know. I mean, the notion that there was at least some grounds for concern about priority, right? I mean, why is a junior lien holder coming in and demanding a trustee sale and making a bid if Markham stays in that senior position? Means to me, I think, that there was some notice. I would agree with you that certainly that the maximum extent of any priority is capped at a certain point and capped short of the credit bid that was actually offered. But what I still don't understand with what you do with the finality of the trustee's deed.
Your Honor, our position is that that Markham's lien remains on the property, and of course the Supreme Court has said that you don't always get extinguishment or a right of foreclosure. There's nothing inconsistent with saying once they exercised rights that they had only because of the 2008 deed of trust, that it's only going to be liens junior to that get extinguished, not senior liens. That's what the statutory scheme contemplates. I mean, and bottom line, what they're doing is asking the court to reorder the priorities under replacement or subrogation, but in a context where they did something that the original lender could not have done. And again, I mean, I don't want to walk through the example in our brief, but if that's the rule, it does mean you could have a $5,000 first position and a lender come in and pay it off, make a credit bid of $4 million, wipe out everybody in between. People don't know what's going on at trustee sales. You're going to undermine the market functions. So again, just conceptually, there's no reason to extinguish Markham's lien, and if that's going to be the rule, it's going to create problems. Let me note too, and I think you made this point too, Judge Swan, that there's a difference between an unjust enrichment claim and the limitations on subrogation and replacement, which is what we're talking about in this case. And let me just check my notes. Unless the court has further questions.
Apparently not.
Okay.
All right.
Thank you.
Well, thank you, counsel, for your arguments. Very helpful. It's an interesting case, and we will take it under advisement at this point, issue a written decision in due course. We now stand adjourned.